Hi, Megha. Am I audible now?
Yes, sir.
Yes. Let me know when to start.
Yes, sir. Good evening, everyone. Welcome to the webinar on arbitration as a career organized by Knowledge Seas. All of you are requested to turn off your microphones in order to avoid any disturbance during the session. The speaker for the evening would be Mr. Arush Khanna. Mr. Arush Khanna is an advocate and legal consultant enrolled with the Bar Council of Delhi. He started his practice in 2012 after graduating from Symbiosis Law School, Pune, has also completed his master's in business laws from National Law School of India University, Bangalore. After having worked with Karanjewala and Co., he started his independent counsel and advisory practice in New Delhi before co-founding Newman Law Offices. The firm, with offices at Delhi and Mumbai, provides in the fields of dispute resolution, arbitration, antitrust, insolvency, and bankruptcy. Some noteworthy accomplishments of Mr. Arush Khanna include appointed India's national representative at Young Lawyers Committee of the International Bar Association in 2017, appointed as an officer of the Young Lawyers Committee at International Bar Association in 2019, appointed to the core committee of Young Members Group of Chartered Institute of International Arbitrators, India, appointed to Law and Justice Committee of PhD Chambers of Commerce, appointed as a member of CI Task Force on Legal Services by Confederation of Indian Industry. I would now request sir to start with this session.
Yeah. Thank you, Megha. I trust I'm audible now. Yes. So thank you, everyone. And firstly, I hope my message finds everyone in the audience in good health and spirit. These are COVID times, and it's very important that we're all safe and keeping good health. At the outset, before I start talking about the topic at hand, I'd like to just thank Knowledge Steeds. It's an absolute pleasure to be invited to speak by them. The work that they're doing is quite remarkable, collaborating with the finest legal minds in the country, legal and young legal minds, as well as senior lawyers, and creating such enriching content for law students and young lawyers, where and during these times where traditional means of imparting knowledge have been impaired seriously on account of the outbreak and spread of COVID-19 in India. So the work that Knowledge Teas is doing is fantastic, and it's an absolute honor to have been asked to speak on arbitration as a career. Now, if that's all right, Megha, what I intend to do is we'll break this into two halves. I have compartmentalized my talk into two heads, into various heads. I'll be addressing a few heads. Then we can open up the floor for some interaction and some question answers. I think that would be better in the interest of engagement. I will start talking on a few topics. Then we'll pause and we'll break for the Q&A of the audience, after which I can take up the remaining. I trust that's all right, Megha. Is that okay?
Yes, sir.
Very well. Now, friends, when we think about choosing a career option as a lawyer, in my humble view, there are three prominent factors that we must keep in mind. The first and foremost is interest. Do you actually like the field of law that you want to pursue a career in the first place? That's number one. Number two is scope. Is it a viable line of work in today's day and age? You need to also understand that the field of law you're choosing has relevance and scope in today's day and age. And of course, third is pragmatic reasons, like monetary factors are also very, very important. So I think these three principal factors define and sort of charter the course of choosing a career option. And I said interest first because the first thing I'd like to talk about is actually interest identification, which is very, very underrated. And I don't think a lot of people talk about it. I think it's imperative for a law student as well as a young lawyer to identify his or her area of interest. Law is a heavy profession. Now, if you don't love what you do, it can take toll on your quality as a professional, and it's not going to, hold you or augur you in good light later on. So you need to really love and be engrossed in what you're doing. Law as a profession historically has a very high attrition rate. There are a lot of lawyers 4 5 years into practice that they just get exhausted. They press the exit option after a few years of practice because they just cannot cope with the fact that they just don't like what they're doing, and it sort of starts taking a toll. So as a young lawyer, according to me, in my humble opinion, there are a few ways of finding your calling. One is, of course, the traditional classroom learning. Of course, that's taken a toll nowadays. Online learning is now quite heavy on account of COVID. Number two is internships. I think internships are invaluable as a law student. And when we speak of arbitration, I think classroom knowledge, online knowledge, internships are, there is another very important component of acquiring knowledge when you're pursuing arbitration, that is collaborating and engaging with institutions and associations and bodies across India and the world. Now, I will be speaking on that in detail later on in my talk, but I think these three things: online classroom learning, internships, and collaborating, because you learn best through osmosis, through observation. And I think this is a great forum for learning. Whilst recent trends have shown that arbitration is a popular career choice, a lot of people are taking to arbitration. It's important that one doesn't go for what's popular and you actually go for what you actually like. Don't move with the herd. If you're fond of arbitration, is not as it's perceived to be a little fancy. It's we have conferences on arbitration happening by the hour nowadays, so it's perceived to be like that. But it's very important for you to actually get deeper into it before you take a call on whether you need to pursue arbitration as a career or not. Speaking of internships, now as I had alluded to earlier, internships are invaluable. Now, I think internships, classroom learning has its restrictions. There's a reason why the line of work we do is called practice. Internships give you that practice. And as a student, it's very important to be involved in all sorts of internships. Like, I always recommend people who are younger to me, who are still, in law school, to try and intern in every possible vertical of law, be it a trial court lawyer. Criminal trial is massive learning. I think you go really down to the root of court practice when you do criminal trial work in India. You must intern with somebody who's a commercial lawyer, a litigator. And nowadays, of course, we have niche arbitrators and arbitration councils as well. And if somebody needs to pursue arbitration as a career, I think 1 or 2 internships with an arbitrator or arbitration council is a must, indispensable. One must intern with a corporate law firm. I think it's very important to know the nature and nuances of transactional law. I think that is the way forward. People are not going to move to court or arbitration. Nowadays, they need to, forge relationships, not fragment them. I think the in-house industry has really blossomed over the last 10, 12 years. We have companies who actually have 50 to 60 lawyers. Take Bharti, Indigo, for example. There's a big names who actually have a lot of counsels. I think that's a very, very rich area of practice. One can also intern with a judge, see what happens at the other side of the table, at the other side of the bench, learn how their psyche works and how they sort of adjudicate on matters, listening and hearing to both sides. So I think these array of experiences are invaluable, and they will help you in identifying what you want. You might not get that choice very easily in a classroom when, there's, well, I mean, more often than not, professors are engaged in a monologue. Half the people may not be even paying that much attention, so it's difficult to get hold of it. And believe you me, try and do that as long as you're in college. You will get a head start. It took me 2 to 3 years into practice to actually know what I wanted, but I think lawyers today's day and age, I mean, law students today's day and age can actually identify that in school, or very in law school, or very early on in their practice. Now that we've spoken about interest identification, I'd like to speak about another very important issue, which a lot of, I mean, people who want to pursue arbitration face. Is litigation a necessary precursor to arbitration? Many modern day arbitration practitioners who are rooting for an independent arbitration bar, and who don't want arbitration to be under the umbrella of litigation, have actually opined. There's a big school of thought that says that it's not important to do litigation if you need to become a good arbitration counsel. I'm slightly old fashioned in this regard. I don't entirely agree. I think litigation as a starting point is actually good ground for pursuing arbitration later on. Firstly, India hardly has any dedicated practitioners. Invariably, we see whoever is practicing in arbitration, we frequently see them in court. Even our Arbitration Act, if you see, permits judicial interference when it comes to, or intervention rather, not interference, intervention in stages of appointment of arbitrators, interim reliefs, recourse against arbitration awards, appeals. So even the Arbitration Act is not bereft of court practice. So you need to be well versed with the court practices. I think one facet of court practice which actually helps immensely in an arbitration is the stage of evidence, the stage of trial. The art of cross-examination is one of the joys of this profession. I would strongly recommend people who are wanting to pursue arbitration as a career to, they can start with litigation and preferably with trial court work, because one should learn the art of cross-examination within the confines of a court, because there you get to adhere to the principles of the CPC and the Evidence Act. And once you can conduct a trial in the four boundaries of the law, strictly speaking, it's easier. It's the transition to arbitration and trials and cross-examinations and arbitrations is slightly easier. It's not that hard. So I would personally recommend working with a commercial practitioner, a litigator for the first 2 years, who of course does some arbitration work as well. So you do get a hang of what arbitration is. I think that's very important. But yeah, jumping into arbitration straight away is also fine. But litigation is very important for acquiring a good skill set needed for an arbitration practitioner. Now, speaking about acquiring a skill set, how does one acquire a skill set for becoming a good arbitration practitioner? I mean, I'm not sounding preachy, but there are various other fields of law, according to me, that where knowledge can be acquired in a far more conventional and traditional manner. For example, classroom online learning. Of course, you have to read your bare acts, you read some case law, and you can clear exams and you can acquire a basic sense of what the law entails. I don't think that holds true for arbitration. For being a good arbitration counsel or an arbitrator, it's not important just to know to do the right thing, but it's also important to know how to do it the right way. And when we speak about the right way, I think in addition to, of course, knowing about the arbitration law in India, the history of the Arbitration Act way back in 1898, when it started with, I think, the Bengal Act, then the 1940 Act, then of course we have the latest act with the two very noteworthy amendments. One was only passed last year. Of course, one needs to be aware of all that and the latest case law that surround arbitration. But very important is to know about the procedural laws and the best practices from associations, institutions, and bodies who have gained credibility in this field across the world. That is indispensable, if you ask me, if you want to pursue arbitration as as an area of practice. Now, when we speak about learning about other facets, just in your, the Arbitration Act, you must read the UN model law, the UNCITRAL model law, from which the Indian Act borrows heavily from. I think even the English Arbitration Act borrows heavily from the UNCITRAL model law. So it's very good to know and very important to know what is the rationale behind the promulgation of the act. So a thorough reading and understanding of the UNCITRAL laws is something that I would highly recommend. The New York and Geneva conventions, uh, which actually give you a great insight not only about what's happening in India, but what is acceptable practice even in a lot of countries. For all countries who've ratified the conventions, there's so many commonalities in arbitration practice. So by being thorough with the conventions and the practices followed, you're actually gaining and enriching yourself with knowledge which is not restricted to India, and it will help you in, say, when you're pursuing international commercial arbitration later on in life, or even earlier on as a lawyer, if you're working with a good law firm. I think they will help you a lot. Having practiced litigation and arbitration for the best part of last 9 years, I believe that there's some legislations in India which are very, very important to an arbitration. They're extensively used in mostly all arbitrations, apart from the law that's sort of governing the main issue at hand. It's very important to have a good, thorough knowledge about the CPC. Now, the Commercial Courts Act is a very important act to have sound knowledge on. The Contract Act, because essentially arbitration is a contract. So one needs to know an arbitration agreement is also a contract. So one needs to know about the nuances of the Contract Act and its various facets. The Evidence Act is very important, even though strictly speaking, the Evidence Act and CPC do not apply to an arbitration. It is not the best practices followed across the world are not a stark, like a departure from the principles laid down in CPC and Evidence Act. And I think there's a judgment also, I think ONGC, Bombay High Court, which actually says that principles of CPC and Evidence Act do have sort of a bearing on a good conduct of an arbitration. So I think that's very important. As I think most of the listeners are aware, institutional arbitration is the way forward. And when I say that, I mean that it's now very important. It's almost like, it's almost a must have that all young lawyers and students need to be well versed with the procedural rules of some of the top arbitration institutions of the world. I mean, when you talk about the gold standard of arbitration institutions, we have the ICC, we have the SIAC. In India, we have the MCIA. So I think it's very, very important to get a good grasp of how arbitration is actually, the entire process of arbitration, how it happens within the confines of an institution. Even though party autonomy is a cornerstone of arbitration, but institutional control and surveillance makes arbitration efficient. And I think it's very important for people to know that. I mean, even my office as a chamber, whenever we are doing an institutional arbitration, the first and foremost thing we do is pick up the book that specifies the procedural norms and read it thoroughly. The game is won and lost in the procedure. It's not your final arguments and everything that act as game changers. I think knowing about each step and how we are to undertake it is very important. So I'd highly recommend young lawyers and students, to be well aware with the institutions. And when I speak of institutions, I also would like to brief you upon the best practices that are followed. The International Bar Association keeps periodically taking out, guidelines on best practices of drafting arbitration clauses. I will be speaking on the importance of drafting a good arbitration clause slightly later, but the International Bar Association has issued many brochures, compendiums, guides on drafting arbitration clauses, taking evidence, which are globally accepted practices across institutions. So therefore, in addition to knowing about the institutions themselves, one must read about the best practices. And of course, one can easily do a Google on what are the best practices and, chalk them out, try and learn about them. They will augur you very well when you graduate, or for young lawyers when you move ahead with practice. There are a lot of these best practices compendiums issued by the Chartered Institute of Arbitrators as well, of which I am also a part. I think they are one of the most credible bodies across the world. They have a dedicated India branch. It is an incorporated entity in India that has a board. I think they're doing fantastic job. So one must keep a tab on what updates are getting churned out from the CIR. I would highly recommend that as well. Now, of course, that was a brief lowdown on what one can do to acquire knowledge on the various facets of law. How one can do it, I would be addressing in the next heading. Basically, this heading, I would like to talk about avenues for acquiring knowledge and experience. What all opportunities can one avail at these associations and institutions, which I just spoke about under my previous head. See, in addition to the core knowledge one acquires in law, one should also bear in mind that there's several associations and institutes across India and the world which offer a wealth of opportunities for one to learn through a host of means. A lot of these, institutions and associations have attending and speaking at events option. So many of these bodies conduct conferences. Of course, now they're all remote conferences through the internet, and they offer a wide array of opportunities for, of course, for the senior lawyers more so, but even for the younger practitioners. So gaining experience and confidence and getting the thrill of interacting with people, front ending operations is very important. So I think whenever one gets an opportunity of attending events, conferences organized by these bodies, one must attend. You learn a lot with interaction. Every conversation for us is an opportunity. A lot of these institutes even have these competitions, on blogging, essay writing. One must participate in all that. I think writing is very important. Again, I will come to the importance of good draftsmanship later on, but I think essay writing is important. Nowadays, of course, I see a lot of colleges having client counseling workshops. I think that's very important. It wasn't there during our time. We had the standard moot court, not even an arbitration moot for that matter. But now we have client counseling because it's very important for a lawyer, or essentially for a litigious / arbitration practitioner, to know how to front end with the client. We're not working in a BPO with great respect where we're just confined to looking into the computer and doing our work. There's a lot more to our practice than just being confined to the cubicles of our offices. One must learn the art of client interaction and good image making. Additionally, there are several crash courses, short courses organized by SIAC, ICC. The Chartered Institute of Arbitrators has an entire module of various courses that every student / young lawyer can take up. I would strongly recommend, because I have personally gained a lot from these courses. I think they offer you things that your college might be constrained to do for want of, adequate faculty, time, or whatever. For reasons best known to them. Nowadays, I'm seeing this slew of measures being taken by these global bodies and organizations, and all of them have dedicated chapters for young lawyers, dedicated mini associations. The ICC has the Young Arbitrators Forum, which is doing very well in India. The YAF India is doing fantastically well. The Chartered Institute of Arbitrators has also a young members uh, group, of which even I am a part. They're also doing some stellar work. We have some great people. I think a few of them, I think Madhav, Deepak, and all have even spoken at Knowledge Teas. So great learning from these people. I myself learned so much. So again, getting affiliated, and these Young Lawyers Association support and encourage students to be a part of it, whether as a member, as volunteers, as speakers, as contributors. These associations, they have realized the value of young law students and young lawyers as important stakeholders in the future of arbitration as a means of dispute redressal in days to come. And as younger lawyers of the bar and students, we need to encash this. because they're actually great opportunities of even I would say, ornamentally speaking, they add a lot to your profile as well. I mean, of course, a lot of us have plans to go in for LLMs and MBAs and higher education. It does embellish your CV to a large extent as well, apart from the practical knowledge and insight that you get. So it's only a gain or a learn for you people. It's really not a loss for having affiliations with this. And I would even say that, I mean, I've having seen a lot of these colleges. I keep going to colleges for some kind of talks, and a lot of these colleges have ADR societies and clubs, as they call it, who have actually tied up with these associations like the CIR, Society of Indian Law Firms, and they're co-hosting events with them at their law schools. So the best minds in the country are going to law schools, conducting competitions, talks, workshops. So I would highly encourage, people who want to pursue arbitration as an area of practice to, get involved with these societies and associations in college itself. It'll give you a great organizational ability, which would not ordinarily come naturally to you just by being a part of the classroom, or just being a part of the herd. I think it's very important for you to get involved, get organized, and get experience right at the threshold, rather than having to wait your turn after practice. So yeah, basically. And of course now, your law schools have a lot of these arbitration moots. The Viz is, of course, the most popular moot. The CIR India branch also is doing a very, very noteworthy moot court competition, or rather moot arbitration competition on international commercial arbitration. I think GD Goenka Law School is hosting that for the last 3 years. Um, so I think they're doing very well. It's very important for you to hone your skills and see whether you actually have the acumen to do it. Having interest is one thing, but to try and grease that interest and hone it, one needs to take part. And taking part in moot competitions and other client counseling competitions gives you a privilege of making an error or a mistake, which is actually very, very important. You may not have that privilege later on when you start practicing, because your client's life and property or money might be at stake. So therefore, do it whilst you have a privilege of making a mistake. And I think it's the best form of learning. With that, Megha, if we can just sort of, give it a pause, and in case, because I've been just speaking for the last like almost half an hour now. So in case anybody wants to ask me a question, in case anybody has a doubt, wants any clarification, I'll be happy to address it before we can move on to the next two facets of this talk.
So we have received a few questions on WhatsApp groups. So the one of the question is, what are the best books or journals to get in-depth knowledge in arbitration?
Redford and Hunter is again gold standard. I would strongly recommend that. ND Basu. I think these two books, one can get a hold of these. I think if you can manage reading these two books, you've done fairly well for yourself. So I think these two journals and books I would, and of course these periodic journals that keep coming in, they're issued by the Chartered Institute of Arbitrators. They're very enriching. They have the latest updates from all across the world. So one are traditional commentaries like your Redfern and Hunter and ND Basu from an Indian angle. But I think reading these journals that keep on getting issued by the best associations in the world is also great periodic knowledge that one needs to be updated, because commentaries often come biannually or annually or after 2-3 years, but these journals give you a pulse-wise update, if I can call it that.
The next question is, if one wants to pursue arbitration as a career, how should they intone at the time like this, when we're in a position of lockdown and everything happening online?
Well, I wish I had a cure to that, but basically, I think virtual internships are the way forward. Health comes first. So whoever's asking this question, stay safe, stay at home, and virtually try and acquire whatever you can. This is by turn of fate. So one has to embrace it and try and make the most out of it. So I guess physical internships for the time being are not going to be possible. But again, arbitration uh, is a very good line of practice to be in, keeping in mind the fact that practice has gone remote. Um, Work from home was a fringe concept a year back. Now it's a focal concept. So one needs to adapt. I don't think there's a way around going out to office unless it's very important or urgent. Yeah, so virtual internships for the time being.
The next question is it better to go for LLM directly after graduation or work experience is a must? What difference does it make?
I would personally like to say to this that I think work experience is a must, because when you're doing LLB, for most parts of it, you're pretty much doing everything that is being offered to you. Very few modules you have a choice in. You have to do the basic laws, but LLM gives you a chance to. Gone are the days where uh, general practitioners could do, whether it's in the healthcare. I mean, when you have a cough and cold or you have a throat ache, you go to an ENT. You don't go to a GP. Likewise, even in the legal field, we are in the era of specialization. It's horses for courses. Try and get work experience, for unless you're really really sure that you want to do this for the rest of your life, go in for an LLM straight after your college. Otherwise, work for 2 years, try and get a hold of what you want, and do an LLM. Don't do a general LLM, in my opinion. Try and streamline what you want and then go for an LLM. So yeah, that's my response to that.
Can you suggest a few good firms dealing exclusively in arbitration where we can intern?
Few good firms. There are lots of good firms, but yeah, I mean, of course, the tier one firms are there. They have great arbitration teams who are doing some great work. We have Ketan, Sam, Cam. Indus is doing good arbitration work. So I mean, of course, but at the same time, it's not very important to see what firm you're working at. I know so many people who are working at top law firms who are getting constricted and stifled. They feel that they're just the last link in the chain. It's very important to have a good boss as a mentor who can really hold your hand initially and teach you the nuances of arbitration. So I mean, brand value doesn't really count. If you want to learn arbitration, find a good mentor, find a good partner. Even if the firm is not good, if your immediate supervisor is a person who you, I mean, look up to as a human being and as a lawyer, I think that's more than enough. Because I know a lot of people working in top law firms. Now I won't take names, but who are actually not happy because they're not getting good work. They're just the last links in the chain. So don't look at the brand. Um, Look at the source of knowledge that you're going to be acquiring. So that's my advice.
So there's another question. I want to pursue corporate law. Can I practice arbitration side by side?
Wow, that's quite a lot of things to do. You want to pursue corporate law and practice arbitration side by side. Well, if you think that you can absorb so much, then God bless you. I mean, honestly, there's so much to corporate law as well. I'm not a corporate lawyer, so I can't speak about how deep or vast it is. But I mean, seriously speaking, arbitration is something. Corporate law is the means to that end. Arbitration is probably the end. It's more curative in nature. In a corporate assignment, when a company merges with another company, there's a joint venture. That is preventive law. Why is company A entering into a JV with company B? They want to solidify their relationship by way of an agreement, so that no issue comes up which is unsolicited or unwarranted or impairs the prospects of commercial practices that they want to pursue. But then one needs an arbitration clause just in case things go wrong. So basically, I call corporate lawyering preventive lawyering and arbitration law curative lawyering, because by the end of the day, if things go wrong, you need to go to arbitration or litigation, depending on whether the agreement has an arbitration clause or not. So if you can have a grip of both, it's great. It's difficult, but yeah. So good luck to you. There's a lot in store.
So the next.
Megha, I can't hear you.
matter where a person is doing law from.
Megha, I have lost you.
Full name matters.
Is this, I hope it's not a problem with my internet. I
The next question is, if a student wishes to enter into the field of arbitration immediately after graduation, how to proceed about it? Because at most places they require work experience.
No, I mean, well, work experience, yes, is of course an added advantage, but a fresher cannot possibly be seen to have work experience. So if one wants to pursue arbitration at the very threshold, then I think there are two avenues. One is to find a counsel who does good arbitration work, or find arbitrators. I know a lot of people in Delhi and maybe even more in Bombay who are just acting as arbitrators. They don't do counsel practice. So perhaps you can look up these people and try and pursue a career with them. But initially, I would say don't work under an arbitrator at the threshold. Learn the nuances of arbitration counsel practice. So if you can find a counsel who does a lot of arbitrations, great. And if you can find a firm which is doing good work in arbitration, even if it's not entirely doing arbitrations, it's not the end of the world. It's okay to be doing a bit of court work as well, because in India, unlike the status in UK or even France for that matter, where I know of arbitrators who haven't even seen a courtroom for 15 years, they only do arbitration. That's not the case in India. So we have to face reality. And even if you don't get a dedicated arbitration team, even if it's commercial lawyering, it will help you in arbitration. And once you get that skill set and work experience, I think it will add some weight to your CV and maybe increase your prospects later on. I think there is some Megha, I've lost you again.
So I'm facing some internet issues. Sorry. The next question is, if a student wishes to enter into the field of arbitration, sorry, what are the best colleges for LLM for specializing in arbitration? And is it
I lost you halfway. You were talking about best colleges.
Uh, I would like to intervene. I think there are some internet issues with Megha. Hello everyone. I'm Mehak Rathi. I'm CEO of Knowledge Teas. So the next question is, which are the best colleges for LLM for specializing in arbitration? And is it advisable to do LLM if one is willing to go into arbitration practice, basically?
Well, I'll be really honest. It's been a while. I crossed college life, so I really can't say which are the best colleges in LLM right now. There's the mids, of course, in Geneva, which is again right up there. But I think the Queen's in London is also doing very well. But I don't think I would be competent enough to answer as to which colleges are doing well right now. As regards LLM, when you're talking about a career in arbitration, yes, I do believe it's important, but I also feel that it's important to get a bit of work experience just so that you are sure, because LLM is a proposition that A, takes a year of your life, and B, it's quite a steep proposition when it comes to monetary consideration. It's an expensive proposition. So if you're investing 1 year, investing a sizable portion of money, it's better to know what you're doing. So practice for 2 years. Even the colleges or the universities would appreciate that, those 2-3 years of practice. Then do an LLM in international commercial arbitration, investment arbitration. Even within arbitration, you'll be amazed to know that there are various sub verticals. So it's not only general LLM in arbitration, there are LLM in various fields of arbitration. Construction arbitration has so many LLM courses. So yes, LLM is important. It's not ornamental as a lot of people feel, but I think you should do some work experience. I think that gives you greater knowledge. having done both, I feel that yeah, practice is a little more enriching.
Right, that was indeed a great reply. So there are people who are not from law background amongst the participant. Few are from engineering sector, few are from other sectors. Also, their question is, being an engineer or being from other sector, how do we enter into arbitration?
Mehak, I think somebody has to mute their mic.
Yeah, I'll just guys, please keep your mics muted.
I lost you in the middle. You were saying something about engineers, which sounded Greek to me, but still I'll try and answer.
Okay, so the question is, as many arbitration cases involves technical know-how, how a person from engineering field can enter into arbitration domain?
Well, in all honesty, even the Arbitration Act that has been amended last year provides for uh, people from other fields, not just the advocacy field, like engineers, chartered accountants, as necessary qualifications, as a criteria for being an arbitrator. And I know so many institutions. In fact, I am personally not of the opinion that lawyers can be the best arbitrators, not at all. I think, insofar as becoming an arbitrator is concerned, even in arbitration counsel, so many times where we're doing arbitration, we're engaging experts in, I mean, let's say I have to assess a claim arising out of an infrastructure issue. I'm not a financial expert. I will be engaging a financial expert who's not going to be a lawyer. He's probably going to be a CFA or a CA or a tax consultant who's going to be assisting me. So gone are the days where advocates had the sole, responsibility or the prerogative of saying or thinking that they're the best arbitrators. I think a lot of institutions are encouraging engineers and people from various fields to be arbitrators. And I think it's very, very important because a lot of arbitration involve nuances which are beyond the capability of lawyers, be it a tax issue, an engineering issue. Now, I mean, a judge of the Delhi, I mean, like a judge of a court, sorry for taking names, but a judge of a court, a retired judge, cannot possibly have the acumen or the bandwidth to understand the nuances of a financial assessment issue. It might be likely, but it's also, he might not be very good at it. So might as well have a person who's a domain expert. If it's a 3-member tribunal, yes, one can be an advocate because he understands the core concepts of law and how to conduct a trial. But there can be 2 other people from various fields that are engaged that form a part of the matter at hand. If it's an engineering issue, then perhaps an engineer. If it's an accountancy issue, perhaps a qualified CFA or a CA. So yeah, it's not yeah. Although this is a lawyer talking to you, but I don't think lawyers are very important and they don't make the best arbitrators.
Okay, that was a nice response. Now we have a very interesting question. Can you provide virtual internship opportunity under you?
Wow. Virtual internship. Well, there is, you can see the firm's website, in all honesty. Just see the firms, make an application, and yeah, we look it up for sure.
Okay. Will it be possible for you to share the website of the firm?
I will share it afterwards. I mean, as soon as it's over, I'll be happy to share it. And yeah, I mean, interested applicants are most welcome.
Right. The next question is, how can we apply for member of Singapore Arbitration Center?
I think you should Google it and find out.
Okay. So as you also mentioned, arbitration in itself is a very broad field. I mean, there can be arbitration in construction laws, there can be arbitration in center, in cyber. There are so many various fields in which arbitration can take place. So is it advisable to do arbitration in general or look for specialization?
So like I answered, I think previously one of your questions, as a student in a law school, you'll have to do pretty much everything in arbitration, and you should, because only once you know everything not know, but you have learned and had a briefing on whatever happens in an arbitration, can you then streamline. You can't just cherry pick and say that I want to do X field in arbitration. First, do arbitration as a whole, get a grip of it. Even people who are specializing in construction arbitration or investment arbitration or IT based arbitration, even their knowledge of arbitration as a whole, generally speaking, is very sound. So I don't think it's fair to cherry pick at the threshold. Yes, you can do that maybe when you're doing an LLM, or maybe when you're working in some law firm which has a dedicated super specialty arbitration team, but otherwise have a general grip over the arbitration laws. I think it's highly advised.
Right. The next question is, how does becoming student members of various institutions like MCIArb, LCIA, etc. helps students?
Well, I think I had briefed on that earlier, but it does. It adds a lot of wings to your life as a student. As a student, ordinarily one would just go to college, or nowadays just log online, I guess. So the exposure you get is limited. I think these institutions, by by so many means, whether it's inviting students for conferences, giving them good opportunities as speakers, and good collaborative opportunities. I think everything, all these things, I as an individual practitioner only realized 3-4 years into practice. But I know for a fact that a lot of students can do it whilst they're students. One should see the websites, learn about their student-based programs, participate in competitions. Whether it's article writing, blogging, vlogging, nowadays it happens. And yeah, I think, and I actually know a lot of students. I have given lectures in Hyderabad, Bhubaneswar, and Ahmedabad, and so many of the students there are already members of the CIArb. In fact, I think some of them even have a grade, associates of CIArb, which is ACIArb, which is grade 1 in when you talk about the grading in CIArb. So a lot of students are doing it at their age. It took me 4-5 years, but you can not make the same mistakes that I did, I guess.
Very, very well said. The next question is, what are the opportunities of being a youth member of MCIA?
Youth member of MCIA. Well, again, like I said, I think it's pretty much a repeat of my last answer. They also have. I was a member in its inception year. I'm no longer a member of the Young MCIA now, but I think it is the premier arbitration institute of the country. It does have I mean, the CIR, in which I am, in which I'm an active part of, we have a lot of programs in collaboration with the MCIA. And I know a lot of students who attend those programs and later on have conversations with us, interact with us. It gives them outlets of internship opportunities, opportunity to participate. And trust me, as a young lawyer, every day is an adventure, every conversation is an opportunity. So just do whatever is feasible. A lot of these courses are even either they're very inexpensive or they're free. So I think you should encash it. It's good fun also. I mean, casually speaking, it's good fun as well to interact with people, get outside your college. And yeah, so that's about it on that question. Yeah.
Right. So the next question that we have is, I would recall it. I mean, when I recall my law school, ADR was covered as a subject in 3 to 4 months, and of course we need practical training also. Internships being one of it, but there are training courses which are there for students. So is it advisable to do these training courses?
Absolutely. Like you, I mean, whoever's asked the question is absolutely right. You're concluding arbitration as a module in college in 3-4 months. I think it's most unfair. 3-4 months, you can't find your colleague in 3-4 months. Let's be very honest. 3-4 months, what, 30-40 classes? And how can a person get to know that he or she likes arbitration or not? So I think these training programs are and they're very, very short. I mean, some of them are online, some of them have these 3-day classes. So many members of the Chartered Institute of Arbitrators conduct classes. Of course, before COVID, when life was normal, one used to have proper classes, holding of classes in Delhi, Bombay, Chennai, and other places. Now, of course, they have online classes. They're good crash courses. They provide for great learning. And like I said, a lot of students do it for embellishing their CV as well, which is fine. I mean, it's not a problem. I think everybody needs to have an impressive CV. So yeah, it's a win-win. And if it's affordable, feasible, and if your college doesn't have a problem with it, I mean, they shouldn't have a problem with it. So yeah, I think one can pursue that.
Okay. We have another interesting question which says, please explain your success story in brief, how you got into arbitration. I mean,
No, I firstly, the irony behind me doing this webinar is I am not exclusively an arbitration practitioner. My first calling is still to the courts. I'm an old-fashioned litigator. So I don't do a lot of arbitrations. Of course, yes, arbitration and commercial law forms a bulk of my area of practice, but I'm not exclusively into arbitration. And the first part of the question, I think I can't, I'm too young and I haven't really achieved a lot to be preaching right now. So pardon me, I don't think I can. I'm a little embarrassed in answering that question, but yeah, maybe in a few years, whoever's asking the question, we can chat up over coffee and maybe have this conversation.
okay, so the next question which we have is, what makes arbitration different from mediation and other forms of alternate dispute resolution?
Well, of course, arbitration has a level of formality affixed to it. There is statutory adjudication when you come to arbitration. There's a finality affixed to it. And of course, the awards are enforceable in courts. Of course, even agreements arising out of mediation can be enforced in courts because by the end of it, they are contracts. But of course, mediation is a milder form of ADR. Arbitration, of course, is a statute that governs arbitration, so you cannot traverse the four walls of a statute. Mediation is far more flexible than an arbitration. It is to a large extent more cost efficient as well. So I think mediation, between mediation and arbitration, if two parties can have a wise counsel to refer their matters to mediation and have them adjudicated by way of compromise, it's highly advised because it's far, far more cost efficient. Arbitration is, compared to mediation, of course, compared to court practice, it's far more flexible because parties have autonomy, but it's still rigid in a way that you're bound by the arbitrator's award. And unlike a decree of the court in a litigation, which can be appealed against, the arbitral award has no appeal. So whatever the arbitral tribunal has adjudicated, save and except for very few reasons under 34 of the Arbitration Act, the award attains finality. So you are bound by the metes and bounds of an arbitration. It's not as flexible as mediation. And yes, for the rest, I guess one will have to see the Arbitration Act. For that, I'll have to take another, virtual class or whatever. Maybe Knowledge Teas would like to have me for that. Let's hope so.
Knowledge Teas would love to have another class. So I think I've tried taking all the questions and we've answered almost all the questions, all the relevant questions. This was a really insightful session. Thank you so much, Arush, for joining us today. And this was just our session. We would like to have you more often for sessions on arbitration per se.
I'll just, Mehak, if I can just take 2-3 minutes just to conclude.
Yes.
I was actually, of course, I'm really grateful for the questions. But I'll just highlight two very important issues for the listeners over here. Our litigious practice or arbitration practice also is steeped in orality. The oral tradition is pervasive in India. There was a quote by a famous lawyer at the Bombay bar. He says, a good lawyer is a person who can conjure magic from a laundry list. By a laundry list, he referred to a bad draft. I think good drafting is a cornerstone of good arbitration practice. You don't win an arbitration by having claptrap final arguments, eye-catchy or ear-catchy final arguments. It is your pleading, which is the motherboard of an arbitration. So I strongly recommend all young lawyers and students to practice good drafting, whether it's knowing about the law of pleadings. There are a host of books on pleadings as well. You must read about them. Keep writing articles. There's so many of these forums now. Even students are starting up with these, publishing forums. Publish them. Even if they're not good or they're not sound, try and make mistakes as students. Like me, at my age, the scope of making an error is very limited, even though I keep making them every now and then. But as students, take this time to start writing. It's a good way of articulating your thoughts in a non-confrontational manner. So good drafting is important, whether it's pleading, whether it's drafting of issues, whether it's affidavit in lieu of examination in chief. Nowadays, the Arbitration Act, as well as the best practice of the world, are encouraging documents only arbitration. So orality needs to go from our practice. We do focus a lot on, oral arguments, and great senior counsels charge a bomb for oral argument, but the cases are won and lost at the stage of pleadings. My last arbitration was actually lost by me because I think that I made some errors in my pleadings itself, though I thought we were very good at final arguments, but the pleadings let us down. So candidly speaking, focus a lot on pleading. Good drafting is important. Do intern with trial court lawyers. And of course, by drafting, I mean even sound drafting of arbitration clauses. You must have heard colloquial terms like pathological clauses or Friday evening clauses. They're, I mean, atrociously drafted clauses. One has to know how to draft a good arbitration clause. The International Bar Association guidelines provide for the best practices of drafting arbitration clauses. Mehak, do I have another minute, or are you going to?
No, you take your time.
Yeah. So I'm trying to be very quick. And now, of course, to conclude, I'll just say that now we are living in the post-COVID world. We'll need to face reality. I just read in the Economic Times today that vaccination by Johnson and Johnson is expected only in early 2021. So, and one is seeing the impact of COVID on litigation. The courts are able to absorb only a fraction of the hearings that they used to do pre-COVID days. But arbitration, institutional arbitration, is doing very well. They've seamlessly moved on to virtual hearings. So the point I'm trying to make is, if ever arbitration was a good choice as a career, it is now. Because arbitration, for the flexibility, the autonomy it offers to the parties, and the infrastructure that some of the top institutions have, arbitration is not going to take a toll. I have a friend in England. His arbitration, his institution is doing brilliantly well. In fact, the caseload has increased. A lot of parties who are litigating in court have made a statement in court that we want to go to arbitration because the courts can't absorb it. Our trial courts are at a standstill. Supreme Court, High Court are taking up. They have five benches are being constituted in a day. So of course, it's taken a toll. So my parting advice would be that I think times are changing, and it's a great time for a student or a young lawyer to pursue arbitration as a career choice. So if you choose to do it, make sure you do it the right way and do it well. Thank you very much. If there are any other concluding questions, quick ones, I'm happy to answer them. Otherwise, Mehak.
Two more questions. If you permit, we can take the questions.
Yeah, two more questions. Then
as you have mentioned about drafting, people are asking what are the good books on drafting, and how should one work on their drafting? I mean, how should one enhance their drafting skills?
The only way to enhance your drafting is by drafting. There's no other way. You can read about drafting, but unless you don't know how to draft. So I focus a lot on good drafting. We lay a great emphasis in our own office. Even if a comma is wrong, it's unacceptable. Good draftsmanship is a cornerstone to good commercial practice, period. You have to just draft it out. Practice. That's why I said good internships, trial court lawyers internship, write articles. Even if it's a bad article, so be it. At least write it. You'll find your way. People will give you feedback. Find your friends or your seniors who can read your articles and give you honest feedback on it. So I would say, write that. I wrote my first article maybe 4 years into practice. You can write it in your third and fourth year. Imagine the head start you'll get. By the time you're my age, you would have had at least 50 plus articles in various magazines, journals, portals, or wherever. So it would have added a lot to your profile, recognition as well. So yeah. Any other question, Mehak?
Yeah, there is one more question.
Sure.
It says, like you mentioned before, students who are associate level at CR. According to you, how does that really help while a student is still in his law school?
How does that not help? If I can ask that question, I think you're only gaining and you're learning. If you've cleared the associate level course, you would have done something for 2 or 3 days with the MCIArb, whether it's, answer some questions, whether it's taking an examination on practical aspects, whether it's a telephonic or a Skype interview or a Zoom interview, as we're doing nowadays. I don't think an interaction with the best minds or an associate level grade, if anybody is aspiring to be an arbitration counsel or an arbitrator later on in life, these qualifications count. And if you can do so as students or as young members of the bar, it'll just augur you well in future. You won't have to do it later on in life. By the time you clear the stages of MCIArb, you would have been in your mid 30s or anything by that time. and you'll still be a young lawyer and you would have cleared the grading in CIR or in any other institution that offers it, I think it'll add a lot of weight to your profile. I think it'll help you being appointed as arbitrator as well, which is a good high and it's good on your pocket as well. I'm sure he or she will understand.
Right, Arush. I think I've taken all the questions, the new questions. Thank you so much for joining us today. It was a really insightful session. Thank you to all the participants, and we would like to have you more often with us for more sessions on arbitration. It was a great learning experience for all the participants.
Thank you very much. It was an absolute pleasure. Thank you, Mehak and Megha. Very kind of both of you to have me over. Thank you very much.
Thank you so much.
Thanks.